Let me do a quick roll call, everyone. Let's start with Mark Corrigan. I'm here. Melanie DePalma.
Here.
Roger Nick. Here. Michael Schwartz. Here. Shelley Sims.
Here.
And Nick Cauliflower, and we are all here. Okay, let me first make a quick announcement. Pursuant to the requirements of the Sunshine Act, the holding of an executive session must be announced at the public meeting prior to said executive session or the next meeting thereafter. An executive meeting will be held immediately following today's public meeting to review matters that are by statute confidential, including the review of completed investigations for the purpose of issuing final adjudications, the review and consideration of applications for 90-day extensions of investigations filed by the investigative division, and finally, administrative and personnel matters. The first item is for approval of the September 23rd, 2020 public meeting. Are there any corrections or additions?
Mr. Chairman, Commissioner
Yes,
Tom,
Melanie.
I have one correction on page 6, the third paragraph, second line. I believe the word commissioner should be changed to commission.
Okay,
And
very good.
That's all I have.
Okay, anyone else have any corrections or additions to the September 23rd public meeting? If none, can I have approval? Roger Nick, did you make the motion? Second by Mark Corrigan. All those in favor signify by saying aye. Aye. The ayes have it. The December 1st, 2020 public meeting minutes, any additions or corrections? Hearing none, all those in favor signify by saying aye.
We need a motion.
Aye.
I'll motion to approve.
Thank you.
And second by Roger Nick. All those in favor signify by saying aye. 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 Michael, you should have stayed in Philly. You know that? No, I'm just kidding. Thank you. Let's go to the first issue is the lobbying opinion, and Mr. Campbell has made a request on the lobbying disclosure law. Mr. Campbell, would you like to make a statement or two before we?
Well, I think we have to introduce it first, Mr. Chairman.
Yeah, that's,
Mark Corrigan speaking.
Yeah, Mr. Campbell, did you want to say a few things?
Mr. Chairman, I think Mr. Corrigan has to introduce the lobbying opinion first before we give the comments from the speaker.
Okay, Mark, you want to introduce the?
Sure. The facts pertaining to this advisory request are as follows. The requester is Loudon L. Campbell, Esquire, who is requesting an advisory opinion on behalf of a client of the law firm Eckert Siemens. Mr. Campbell seeks clarification as to the proper interpretation of section 13A05B5 of the Pennsylvania Lobbying Disclosure Law. Specifically, Mr. Campbell notes that expense reports filed pursuant to the Lobbying Disclosure Law shall report that the identity of any individual, association, corporation, partnership, business trust, or other business entity which contributed more than 10% of the total resources received by the principal during the reporting period. Whereas the lobbying disclosure regs require the identification of any contributions totaling more than 10% of the total resources for lobbying received by the principal during the reporting period. Mr. Campbell notes the lobbying disclosure regs include the words "for lobbying," which the lobbying disclosure statute does not. Mr. Campbell submits that the regs clarify that only those contributions for lobbying totaling 10% or more received during a quarter are required to be reported, as opposed to all contributions of 10% or more received by a principal. To illustrate his position, Mr. Campbell suggests that when an entity also engages and receives contributions for non-lobbying activities, including preparing and filing an amicus curiae briefs with the courts, the regulations clarify that only those contributions for lobbying are required to be disclosed and not those specified for the filing of briefs. Mr. Chair, at this time, I would suggest that it would be an appropriate time for any interested parties to speak on this matter.
Okay, Mr. L. Campbell, would you like to make some remarks?
Yes, I think you've all seen my submission of March 18th. And we, of course, maybe by the way, I should introduce my client who is on the phone at this time. And his name is Kurt Schroeder. And Mr. Schroeder is the executive director of the Pennsylvania Coalition for Civil Justice Reform. And initially, when we looked at the regulations, we were concerned that there might be a conflict between Section 13805 of the Act, along a conflict with the regulation as opposed to Section 13805 of the Act at subsection B5. But our review of it leads me to suggest that, as you can see, the first several pages of my submission indicates, first of all, that the chapter relates to lobbying disclosure. That's Section 13A01 of the Lobbying Disclosure Act. The next relevant subsection is 13A02, which is the statement of intent and jurisdiction. And you can see in subsection A, the intent here has to do with the identity and scope of activities of those who are paid to influence the actions of the General Assembly and the Executive Department, and they need to be publicly and regularly disclosed. Subsection B of Section 13A02 of the Act talks about jurisdiction, and I know you have my submission, but you'll note that the highlighted point says this chapter is not intended to govern professional activities that do not include lobbying, and are properly the subject of regulation by the judicial branch of government or by any government agency. So when we looked at that, we said even though the statutory provision does not include the words for lobbying, we believe the scope of the Act is sufficient, and that defines the Act to have to do with lobbying and lobbying disclosure. So having said all that, we suggested that the Commission should clarify that when activities of an entity that does engage in lobbying, but have also other activities that have nothing to do with lobbying. And in this case, one of the things that this client is concerned about is the ability to, the ability to say that the Act, the scope of the Act, specifically is restricted to lobbying. And since there's no lobbying involved in these other activities, we believe there really isn't a conflict between the Act and the regulation. So having said that, I'd be happy to try and answer any questions.
Okay, thank you, Mr. Campbell. Anyone have a question or two to ask of Mr. Campbell? Let me just start by saying I somehow think that we're being asked to clarify some things in the law, and I'm not so sure at this point that we ought to make a decision about this. But again, let me open it up for questions. Mark, do you have a question since it's
Well, before I do, I would suggest that, I don't have any questions for Mr. Loudon, but I think that, or Mr. Campbell, excuse me, but I think perhaps we ought to go into our quasi-judicial deliberations. If no one has any questions for Mr. Campbell.
Okay, that's a motion by, Mr. Corrigan. Can I have a second, and we'll do that?
Second.
Second by Roger. Nick, all those in favor signify by saying aye. 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 Okay, let's do that. Mr. Campbell, I guess you're gonna have to leave the room for a little bit.
Mr. Campbell?
Yes, Mr. Campbell is here.
Okay.
Oh, okay, we can continue. Mark Corrigan here again. In the motion I'm about to make, the term lobbying disclosure law refers to Act 134 of 2006. I move that the holding of this commission in this matter be as follows. For purposes of filing quarterly expense reports pursuant to the lobbying disclosure law and the lobbying disclosure regulations, the law firm client would be required to disclose on each quarterly expense report the name, permanent business address, and daytime telephone number of any individual, association, corporation, partnership, business trust, or other business entity which contributed more than 10% of the total resources for lobbying received by the principal during the reporting period. The requirement to report would only include those contributions of more than 10% received by the principal and utilized for lobbying. That's the motion, Mr. Chairman.
Thank you very much, Mark. Can I have a second?
Second, De Palma.
Okay, second by Melanie De Palma. Any questions? All those in favor? Well, shall I call the individual roll, or?
Yeah, I think that,
Let me call the individual roll. Mark Corrigan,
Aye.
Melanie De Palma,
Aye.
Roger Nick,
Aye.
Michael Schwartz,
Aye.
Shelley Sims,
Aye.
Nick Colfellows, and I too. The ayes have it. All those in favor signify, well, we've all done that, signify by saying, do we have any no votes? The ayes have it. Thank you very much. Well, I'm stuck here. I'm not sure, was I supposed to ask Mr. Campbell to make any remarks? I don't think so, do I?
No, I think we're finished with
Yeah.
that.
Okay, that's,
Well, I want to express my thanks to the commission, and much appreciated, and I think this is clearly the right answer. Thank you very much.
Thank you.
thank you.
okay. Let's go to item 4, the civil penalty orders. Mr. Schwartz on Parker.
Mr. Campbell is going to exit now. Thank you very much.
Okay.
Yes, Mr. Chairman. This case involves respondent Lataya Parker Burhan, who failed to timely file statements of financial interest for calendar year 2018. The only twist in this case is that respondent was served a notice letter, a final notice letter, each of which informed her of her delinquency and provided her an opportunity to avoid the civil penalty. The respondent did file the delinquent form at that point in time, even though she was given more than the usual grace period. Then civil penalty proceedings were instituted against the respondent. When they were instituted, she did file her delinquent statement of financial interest for 2018. And then she filed what she called an answer. This was before an order to show cause was issued, but after a formal proceeding was instituted. And in her answer, she said that she was employed as an HR representative with the executive offices of the governor from about September 18th to approximately February 19th. She said that she attempted to file a statement of financial interest when she was employed, and that she telephoned the commission in approximately October of 2019 and again in December 19, because she was not able, according to her, to access the Commonwealth's online filing system once she became a former Commonwealth employee. The respondent has not requested a hearing after an order to show cause was filed, and the question is whether or not we should levy the maximum civil penalty of $250 as we ordinarily would do for the failure to file, or whether this answer that came up establishes any type of mitigating circumstances. I am of the opinion that she had two opportunities to get her form in when we issued a notice letter and a final notice letter. And even though she eventually filed her form once the penalty proceeding was instituted, that is not a sufficient excuse or mitigation, and that we should move forward with $250 against her for delinquent statement of financial interest. But I open that question because this is one where it's not a pure default. She has remedied the situation, although it is significantly belated. So before making a motion, I wanted to present the case to see if anyone thought that there should be a penalty of less than $250.
Hearing none.
I will make the motion. I therefore move that the commission levy the maximum civil penalty in the total amount of $250 against respondent Latoya Parker Berman for failing to timely file a statement of financial interest for calendar year 2018.
Thank you, Michael. Motion made by Mr. Schwartz, second by Mark Corrigan.
Sure.
Any questions? All those in favor signify by saying aye.
Aye.
Aye. Nay?
Aye.
The ayes have it. Let's go to the next,
I'll try to do this one very quickly if I could.
well, that's right, you got the next one too, go ahead.
We have 5 civil penalty defaults. Let me just tell the names as their positions and the years, and then I'll move for imposition of penalties. Dennis Harris, a physician with the Pennsylvania Department of Human Services, failed to file for 2018. Keith Still, a high school principal for Susquehanna Township School District, failed to file for 2018. Akila Ingram, an income maintenance caseworker with the Department of Human Service, failed to file for 2018. Sharif Grievous, an income maintenance caseworker for the Pennsylvania Department of Human Services, failed to file for 2018. And Thomas Gustovich, a school director for the Bethlehem Center School District, failed to file for 2015, 16, and 17. I want to make note that it's particularly troubling that a school director, a principal, and a physician with the Department of Human Services failed to file. I would therefore move that we levy maximum civil penalties in these 5 civil penalty cases, with the first 4 being for $250, that's for Dennis Harris, Keith Still, Akila Ingram, and Sharif Grievous, and for Thomas Gustovich, that we have 3 years, that the civil penalty be $750, and that all 5 of these respondents be ordered to file their statement of financial interest for the years stated within 30 days of the issuance of the Commission's orders.
Motion made by Michael Schwartz, second.
Second, Commissioner Sims?
Is that Shelley?
Yes, it is.
Okay, Shelley Sims makes, seconded. Any questions? All those in favor signify by saying aye.
Aye.
Aye. Nay? The ayes have it. Thank you, Michael, very much. That concludes the public meeting, and I guess I need a motion that to end the meeting. Can I have a motion? Roger, Nick makes the motion. Well, I felt like I got a lot of power here. Seconded by Valerie De Palma. All those in favor signify by saying aye.
Aye.
Aye, nay, the ayes have it.
Remember, we granted you all those powers too, Nick.